Meeting begins to assemble.
78, the board package where other states issues. Yes. Board members have other questions?
Mr. Chairman,
Yes.
since the gentleman isn't here from Fort Kent, I don't have a question. I think I have the distinct pleasure of having gotten up the earliest and driven the furthest to be here this morning. I had hoped this could be put off so I could have my 1 week at camp, but when I got up there last Friday night, needed some paper to start the fire, I went to the packet, and you can't imagine how tickled I was to find this in here. And Mr. Cadeau will be pretty proud of me because I read the whole thing. And I've taken some notes, and I hope people bear with me. And I would say at the onset, I don't want to offend anybody personally. And I'm not very good at this sort of thing, and people that have sat with me know that I'm not. But I'm going to have to refer to names, and all I'm interested in is what people said. I read this over before the public hearing, and I had some concerns, but I came to the public hearing very objective. I listened to the department's introduction, and my concerns really weren't appeased. And I listened to and participated in the public hearing, and by the time it was done, my concerns had grown into opposition. And quite frankly, there hasn't been anything that's happened thus far that's changed that. So, I apologize for my notes. They're done under a Coleman Lantern, and I may get a little bit confused, but I would move that we strip, and I make a motion that we strip from this proposal the new language having to do with vessel operation, sections 4, 8, and 10, and retain those portions having to do with oil discharge prevention and pollution control at marine oil terminals and transportation pipelines as amended. Now, apparently the title of this would change somewheres, and I didn't miss that, but the public hearing doesn't say anything about operation of a vessel, doesn't include it in the title that I got. As I've said on this board, before I've cast any vote, I've always tried to ascertain the additional benefits to the environment if a new rule was passed, versus what costs there were to the environment if the rule was not passed. And I asked this question specifically at the public hearing, as did someone else. And what I asked a question and related it to the 2 previous oil spills magnitude, which I am familiar with, and the answer from staff was that these new rules would not have prevented either spill, and there was no assurance any future spills would be prevented with the adoption of these rules. Now, I'm speaking now of just vessel operation. As far as I'm concerned, the terminal part's great, and pass it today. So as I go through this, I'm talking about vessel operation. If I go back to when I used to teach problems with democracy many years ago, I taught those kids that for new legislation to be passed, whether it was a planning board at Greenville or something they're doing in Congress today, that for new legislation to be passed and meet the standard of democracy lived in, it should be attainable and quantifiable. Mr. Cadeau, those are pretty big words for me, I know, but and this, as far as I'm concerned, is neither. In introduction, the department stated it wanted additional vessel oversight, so that we are not merely a passive player in an incident with a vessel. This was referred to over and over by the department as having a seat at the table. The state wanted to be in a position to be a player in the decision-making and handling of vessels. In reading further testimony, it would appear to me that they already are at the table, and the state testified at the table to the extent that federal statute permits. And they testified about early on at the Julianne spill, some suggestions that they made, and the feds followed it and probably resulted in the spill being less than it was. I read in particular I read all of this over and over, but in particular what the Coast Guard had to say. And bear with me. What does the Coast Guard have to say about state regulation of vessels? If you go to page 42 of the testimony, it says that there are joint efforts, there's a forum that has enjoyed many successes, including establishment of underkeel clearance guidelines, a new weather service buoy off the port of Portland, the designation of a recommended route for large vessels transecting Penobscot Bay. The Coast Guard, the Maine DEP also worked hand in hand with every committee addressing pollution response and contingency planning. This group was recently selected as a model of best practice in federal and state relations. It goes on to say that it's the first ever regionally regulated navigation area. But the part that on page 43 of the Coast Guard testimony, which I felt was most important, because breaking ranks with universally accepted international standard weakens the overarching regulatory regime. It creates confusion and uncertainty in the industry, which personally leads to degradation of safety, and it triggers the preemptive issues, which is now in the court. If individual states are allowed to regulate tank vessels and their operation, several adverse consequences could ensue. First, the United States leadership position in the international regulatory community would be severely undermined. Most, if not all, Coast Guard regulations in this area are premised on international standards ratified by the United States government. These international instruments are the results of a hard-fought negotiations at international maritime organizations. If individual states are allowed to enact their own rules, international players will quickly lose interest in tougher international standards. There simply will be no initiative for them to agree to these tough standards if they are not uniformly applied throughout the world. The world's a big place. Taken to the extreme, state regulation of tank vessel operations could undermine international maritime law. Now, to this old game warden, that's pretty serious, and probably as serious as any vote I've ever cast at anything in the public sector yet. Now, I'll remind you that the Coast Guard was under oath when they stated that, as was everybody else that's here. lastly, speaking of the Coast Guard, the department many times refers to the current excellent relationship with federal authorities. And further on in here, and now we found out this is going to the court, so maybe I don't have to get into it, but the Port and Waterways Safety Act requires that the feds consult and consider state and local views in establishing tanker regulations. It says to read comment 19. Bear with me. Comment 19 says, the unified command structure under federal law makes Maine an equal player with the Coast Guard in any spill response. The state already has a seat at the table. It does not need these rules. The state, in their response to this, really doesn't refute that. Okay, it is my reading that through the views and acts, the Coast Guard has the authority to demand, I won't try to find and read it, but it is, in my reading, through the various federal acts, the Coast Guard has the authority to demand all the controls that the department is asking for, and the department does not refute this. So anything that the department wants, the Coast Guard has the ability to get, and they're doing it now. The Coast Guard has repeatedly, on the record with letters to the governor, stated that they will do whatever the statute allows by entering into memorandums of agreement to coordinate state and federal policy and activity relating to marine pollution. You know, never was in the Coast Guard, don't know anything about them other than that they regulate me. I really don't know what more the Coast Guard can do. Going on, a member of the staff contacted me after the public hearing and initiated a conversation. In fact, the member of the staff couldn't understand. Remember, we had a straw vote after the public hearing and couldn't understand how I had said that there was little to no support on vessel operation at the public hearing. So I have gone through, because I can stand to be corrected, and I've made mistakes, and that's why I carry pencils with erasers on. But I've read it over as close as I can, and remember what I said about articulable and quantifiable. If you read the first person who spoke in favor, man from Sitco, pages 10, he said, I generally support the terminal rules with some minor questions and comments that I'll file. I do not agree with the department's attempt to regulate maritime functions. On page 14, he says, I can tell you that multi-layered levels of regulation from both state and federal levels become extremely burdensome and difficult to comply with. If there's a situation where federal rule or state rule, if there is a situation where a federal rule or a state rule is the ability to decide which takes precedent or which body has primacy over enforcing these regulations, that's a concern that we have as a regulatory party standpoint. If that guy's speaking in favor, I guess I don't understand. The lady who used to be on the board, nice lady, you know, I'm glad that she came. It was kind of refreshing to hear her speak. And I don't mean this to be disrespectful at all, but she didn't ever speak specifically to vessel operation. Ron Huber, I'll give you that one. He does speak to vessel operation, but he offers no specifics. Conservation Law Foundation, and I don't mean this disrespectfully, but I heard them testify once that they never saw an environmental regulation that they didn't like. And, you know, if you read their testimony here, again, they don't get into any specifics. The representative from down to Bedford never spoke to vessel operation. The man from Friends of Casco Bay, and I guess Porter should put on the record that our business is a strong supporter of the Friends of Casco Bay. I couldn't understand what he was saying, and I asked him when he got done to tell us exactly how he felt about these vessel regulations, and he never said anything I could understand. And if you read the record, Dr. Toohey took over, and he's certainly a lot better than I am, and I don't think he satisfied Dr. Toohey, but Dr. Toohey can speak to that himself. The gentleman, last proponent, was a gentleman from Mobile, and you recall that the chairman had to ask him if he was in fact speaking as a proponent. But he said he was a proponent. But if you read it, what he said. To the DEP's credit, they set up 2 meetings at the end to address the vessel issues, and for various reasons there wasn't progress on those issues at these meetings. Vessel issues didn't receive what we would call the appropriate amount of attention. We recommend that portion be remanded back. That's, in summary, neither the department nor any of those speaking as proponents gave any evidence as to how this controversial portion of the stakeholders' effort would have prevented either of the 2 large spills that I spoke of before, or would provide any more prevention in the future than does current statute do. The strongest language that I can find from the department comment 67, which it's on page, I got mixed up here, I'm sorry. It's comment 5, it's the top of page 67. In general, the environmental benefits to be gained by revisions of Chapter 600 vessel rules are to guard the state against adverse and potentially devastating impacts of coastal oil spills by giving the department the authority to bar entry of unsafe transport vessels, to require the vessels to be seaworthy, and reduce the probability of vessel accidents through visibility guidelines, docking plans, adequate staffing, and training of staff. Unequivocally, the feds do all of that now. All right, the department further tries to justify this proposal with the other state's argument. In all due respect, ma'am, I disagree with what you said. If you do a critical analysis of other states. Okay. Page 77. Texas speaks of loading and unloading. Louise. Every time you would do something like that.
There's the board.
First grandson last week.
From the stars of the show.
Well, good morning, everyone. Welcome to this October 21, 1999 meeting of the Board of Environmental Protection. My name is Osman Bonsey. I'm a board member from the town of Surrey and the chairman of the board. Others here at the head table on my left, board members Andrew Caddo from Freeport, Kathy Littlefield from Waldo, John Marsh from West Gardner, Ernest Hilton from Starks, and Dean Wilkinson from Cumberland. On my right, Brooke Barnes, Deputy Commissioner, Melissa McClellan, Board Secretary, John Dewey, Board Member from Gorham, and John Edwards, Assistant Attorney General. Let's begin this morning with the usual subject, a report from the Commissioner's Corner.
Good morning.
Morning.
I'm just off vacation. This is foreign country. I sort of got the same facial fungus and things as Executive John Tully with you and out there. Yes. It's more a matter of now sort of nailing that down to the governor's office and then having the Senate in town to meet the confirmation. To meet with you. And of course, one of the critical issues they're looking at is our department and the board too close. The department influenced the board too much. I think that really is your opportunity to speak your mind about those issues. And I don't want to, if you need information, be glad to provide it, but hadn't planned on giving you any particular information.
I think you bring up a good question, though. The board perhaps should have this as an agenda item at our first November meeting to discuss in public what our thoughts and positions may be going into that meeting. Yes, and I had a call from Virginia Plummer, who's the other board member who's not with us here today, sort of asking me the same question. Are we going to have an opportunity as a board to talk about what thoughts we may express to the committee? So can we put that as an agenda item for that discussion?
And that's the next meeting?
Yeah, but I'd be, and then 2 weeks later, the committee's got any questions relative to those meetings?
Is it anticipated that most or all board members would attend both of the 22nd and the 29th meetings?
I think that's a matter of individual choice. Personally, I think I'll probably go to the Bangor meeting just to sit in and listen.
That was my thought too. I hadn't anticipated going to the Portland meeting.
I would not, I don't plan to say anything at those hearings, but just to see.
I'll be at the 2 o'clock.
Patty Aho.
Hearing
In Portland.
and I'll attend the 2 o'clock meeting tomorrow.
Okay, other questions in regard to the board's calendar? Departmental orders. Any questions on departmental orders, which seem to be an unusually large number?
Well, I have a question on the application. See, we've got China Lake back.
Rivers and streams, Barry Moore.
Good
morning, members of the board. I'm Barry Moore, Bureau of Land and Water Quality. I'm on the agenda. I'm supposed to be here to recommend you adopt Chapter 585, dissolved oxygen requirements for rivers and streams. However,
We're going to change Assistant Attorney General here, so we'll just take a minute before we start the next order. Mary Sauer is going to join us at this moment. Now go to item 3 of our regular agenda, Chapter 600, Oil Discharge Prevention and Pollution Control at Marine Oil Terminals and Transportation Pipelines. Dave, statement.
Chairman Bonsey, members of the board, good morning. I'm Dave State, with the Bureau of Remediation and Waste Management. I'm here this morning to ask you to adopt the amendments to Chapter 600. We've talked about the extensive development process that we went through to formulate these rules. You have received public comment during the hearing and writing afterwards. We have responded to those comments and made changes to the rules based on those comments. At the posting, I stated that there was fairly good agreement on the terminal and pipeline portion of the rules, and that there was considerable controversy regarding the vessel portion of the rules. I believe that the testimony that we received, in fact, reflects that, and the comments that we received on the terminal portions were fairly minor and technical in nature, and the comments that we received on the vessel portion were considerably more comment was received, and considerably more opposition. I believe, however, those comments clarified the issue when we boil them down, that it really does become more of a question of should the state have rules governing vessels or not. The department believes that these rules are appropriate in keeping with legislative intent, and I hope you concur. There are a couple of things that I would like to note for you. First, regarding the board packet. When we took the individual items, some of which were information that the board had requested, if you look at them individually, they seem to make sense, but when you kind of put them all together in a pile and start looking at them, we had some fear that they may have actually been confusing. So I thought it was worthwhile to go through these and explain the various elements a little bit. I won't spend time on the basis statement of the conveying memo. I will go instead to page 113, existing vessel rules, and that is the sections. That is the rule with the sections that apply to vessels starred. As you had requested, so that you could look at what standards are currently in force. Then I go to page 130, which is the final rule. Actually, the final rule, not as it is for the public hearing, but as it will appear in the end, but with the sections that, with everything but the sections that apply to vessels X out, so that again, you could look at, easily look at the rule and see what sections actually will apply to vessels. The next item is page 146, and this is a copy of the actual Code of Federal Regulations, the Coast Guard regulations that we have proposed for adoption. It's photocopies out of the CFR, and began in the portions that were not adopted, so that you would see only the sections that we actually adopted. Those sections that we did not adopt have been Xed out.
So you're really talking about page 147.
Yes, 146 is really the cover page.
Yeah.
I haven't marked those, and probably I should have marked together. The next that you see is page 162, which is the rule that's required to go for public hearing. It shows all the changes and the new language. And while I'm there, I want to draw your attention to an error that we found, that based on comment that we received at the public hearing, we changed the title. And on the title page 162, the bold oil discharge prevention and pollution control at marine oil terminals and transportation pipeline regulation at the top of the page should have been a line through it. And therefore that error is carried through onto page 223, and that title appears and should not have, the new title should have appeared there, which you see on 162 below that is underlined. And then finally, page 223 and beyond is what the final rule will look like should you adopt it. I hope that clarified any confusion we might have created with that. The next thing that I wanted to note was that during the Supreme Court has, in fact, agreed to hear the appeal of the Washington, or the Ninth Circuit Court decision on the Washington rules. In the public comment process, there was suggestion that the department and the board should hold an abeyance acting on these rules. And we have received communications since the close of comment to the department, and especially since the Supreme Court has agreed to hear this case, that we should not make a final decision on those rules. And I wanted you to know that. We don't agree that you should, in fact, hold the decision in abeyance. We believe that you should act on the rules. And there's a couple of reasons actually a number of reasons that I hope you will consider. I think an important one is that if we were asking you to go into an area where the department had never regulated before, then I think that perhaps that would bear more consideration. But the fact is that the department has rules currently regarding vessels. And if you look at the arguments of those who contend that you should hold these in abeyance, that they will argue before the Supreme Court that the state should have no right to regulate at all in this area. And so the state already has a stake in that case, regardless of whether you adopt these standards or not. We already have rules. We already have the potential for being effective. And whether or not you act on these amendments will not change that. Secondly, I think an important question you should ask, is there harm to the individuals that are regulated by this if you should adopt these rules during the interim period? And again, the fact is that these rules, any operator who is operating as a prudent operator at a standard that they should be operating is not going to have to do or lay out huge amounts of money or do things that they should not already be doing in general. And finally, I would suggest that the reason that to some extent has to do with it's in my own best interest, that should you decide not to adopt the rules, that we would, at such time as it was appropriate for us to proceed, we would have to go through the same arduous process that we have to get to this point. public hearing, basis statement, all of that. And essentially, if there is a ruling from the Supreme Court that affects the rule in part, it will be a very simple decision for both us and you to repeal those amendments. I doubt that there would be any controversy at that point. It would be a very simple act, and the department has already shown that we're willing to do that. We did that based on the Ninth Circuit Court decision. We took the rule, we went over it based on the Ninth Circuit ruling, and we changed the rule so that it would not be, in effect, comply with the Ninth Circuit decision. And we would do exactly the same thing if the Supreme Court were to rule unfavorably on a portion of our rule. With that, I thank you, and available for questions as our most of the folks who worked on this rule.
Mr. Say, one of the principal points that was made at the time of the public hearing was that no other states, except Washington, I guess, had adopted such regulations, and yet in your response that you put together, you listed several states that had in fact adopted special regulations. Could you just comment on that and review that again a little bit for me?
Would it be appropriate if Stacey Ladner answered that, and that she was the one that did most of that work, and I think can answer it better than me?
Good morning. Based upon our research, we found a number of states that have regulations regulating vessels, and we put a few of those into the basis statement with some summaries of some of the items that those states had, and it just isn't factually accurate that Washington State and Maine are the only two states that currently regulate vessels. There actually are about 2/3 of the coastal states actually regulate vessels at this point. So, I don't know in how much more detail you'd like
So
me to.
vessels coming into all those states have got to understand what those regulations are as well as the federal regulations.
That's correct. And the requirements for the various states vary depending on what they're particularly interested in. You know, for example, Louisiana has an import requirement where the vessel has to file a report and notify whether they've had any problems that would be of concern to Louisiana before they come into that port. So there are various standards for various states, and it depends on what that particular state is interested in, what the concerns are with that state.
The board's information on pages 7